Okay, thank you. So at this point, we have 3 trios and a pair. So let's, those asking questions, let's try and be as succinct as we can. The first threesome will be Tom Colby, myself, and Laurie Klaus.
Okay, I think this is a great paper. I think it's really helpful to the originalist project when those who don't write much in originalist theory are actually out there going through the history and doing the heavy lifting of figuring out the original meaning of particular constitutional provisions. So thank you for that. What I want to say here is more of a comment, I guess, than a question, and a mercifully short one. I think this paper and the reception that it does or doesn't get from originalists on the bench will be a good measure of the practical import and the practical constraining potential of originalism, an issue that's near and dear to my heart. At the end of the paper, you suggest that maybe the court has too much invested in its originalist story to ever admit that it's wrong about the facts, that it's wrong about the history here. I'm inclined to agree with that, but if that's right, what does that tell us about the utility of originalism in practice? If the courts are only going to draw upon originalist scholarly work when it supports the justice's preconceived notion of what the answer should be, then however constraining originalism might be in theory, and I have my doubts about that, it's not going to end up constraining judges in practice very much at all. And I think this will be a nice test case for that.
Well, my question is a really simple one, and simple-minded maybe. I only ask because I really actually want to know the answer. And I guess it kind of runs contrary to the tenor of Tom's question. So it's just this. You say that the history that you describe shows that there was not historically understood to be an injury in fact requirement. And somewhat to my surprise, Caleb conceded that point, it seems like. But the simple question would be this. If the cases, these ex parte cases that you're talking about, are cases in which someone goes in and, as I think you say, just asks for a declaration or a registration of a right, isn't it almost automatically true that it's a right that isn't currently being recognized, which a right to some sort of benefit or something that isn't being given? So if you take, for example, your pension cases, I would think someone who goes in and says, you know, I want you to declare that I have a right to a pension, thinks he has a right to a pension, isn't getting it right now, and is trying to get it. I don't understand why the non-recognition of some benefit for a person wouldn't count as an injury, showing that there may well have been an injury in fact requirement. Okay, good.
Yes, so when reading this rich account of the early judicial practice, I wondered what we should make of a little moment fairly late in the life of the Philadelphia Convention that I just remembered. The little moment when Dr. Johnson proposes adding this constitution to the all cases arising under formula in Article 3, and Madison, according to his own notes, gets up and says, "Oh, hang on, that's going too far. Unless it's limited to cases of a, quote, judiciary nature," right? And then they make the change, include this constitution, this language that much more clearly establishes constitutional review, not just statutory review. According to Madison's notes, it being generally supposed that the provision was constructively limited to cases of a judiciary nature, as if this is some significant constraint on what these courts are going to get to play with here. So I guess that my question would be what we think, what this general supposition was. This is something that, it's according to Madison's notes, this is something they all thought, that there was this constraint that just followed, and they called it judiciary nature, and what were they meaning? It's got to be at least no advisory opinions, I guess, maybe, or something like that. But I guess that would be the question. How much juice is there in that concept that they're all thinking is real?
In response to Tom, I'll just say I'm looking forward to hearing the answer as well. I think one of the testing cases may be applications for fee waivers under the PACER statute, which authorizes individuals, if they want access to judicial records online, to petition for relief from the requirement that they pay fees to the judicial conference to obtain access to those records. And when district courts turn those claims down, as they sometimes do, the circuit courts have uniformly concluded that there is no case in the district court and therefore no Article 3 power to conduct appellate review of even an erroneous district court determination of a PACER waiver application, which strikes me as wrongheaded from an Article III perspective, but also inconsistent with Tattoon, which was exactly the same situation, right? An application for naturalization of the district court that the circuit courts were refusing to hear on the ground that it really wasn't a case within the Article III structure, and that was the correction, that was the problem that led to the correction by the Supreme Court in that case. So it will be interesting to see what the court chooses to do. It has quietly validated every instance of non-contentious jurisdiction that it has confronted, but it has never really, I think, struggled with the disconnect between rhetoric and practice. And I think the PACER fee may be an opportunity for it to struggle with that gap. So is there an injury in fact? In many cases when you are seeking judicial review of an agency determination, you have been injured by the denial, by the agency's denial of your claim of right, be it naturalization or be it a pension or otherwise. But when you're making an original application for the recognition, you haven't been injured. You're claiming a right that Congress has afforded to you, and you're simply going through the legally required steps. As Marshall said, you're asserting your rights in the form required by law to obtain, as I think Caleb correctly points out, an investigative decision that recognizes that you now are in a different legal position than you were before. You got married, you got divorced, your probate application was approved, and now you're the executor of the estate with the legal authority to act as such. These are all examples of non-contentious judicial power that do not necessarily entail remediation for an injury. Although the instinct that underlies the question, I think, is quite right in the sense that one could, I think, model the application as potentially a seeking redress for the government's failure to have recognized your entitlement to the pension or to naturalized citizenship and to bestow it upon you. It seems to me that it's hard to make an argument from injury based on the government's requirement that you take the affirmative step of demonstrating that you qualify for the right in question. I like Larry's comment about judicial power and the judiciary nature. A quote that many of us have found a use for in our discussions of the history of Article III. I've certainly relied on it a time or two myself. And so I think it does provide perhaps much better evidence of the proposition that there was a conception of the nature of the judicial power that was alive in the day, and that there was some conception that was embedded in Madison's comment. But I don't think that comment itself gets us any closer to understanding what the framers would have had in mind. The argument here is that many things that we have previously characterized as purely ministerial are properly characterized as judicial acts and would have been understood as acts of a judiciary nature at the time Madison was speaking. And so that's the corrective we would offer, but not necessarily a rejection of your invocation of that very interesting language.
Okay, thank you.
Caleb, do you want to jump in as well?
Let me just add a couple of things. One on the PACER thing. One possible distinction between the PACER fee situation and the citizenship stuff is that fees for access to PACER seem to me to be kind of internal to the judicial branch in a way that the citizenship stuff isn't. And so I'm not sure they have to be a case in order for the courts to be able to grant a fee waiver any more than it has to be a case for the judge to decide whom to hire or for the court to decide whom to hire as a law clerk. Right? So I'm not sure everything the judicial branch does has to be fit into the case or controversy language, even if you do view there to be a case or controversy requirement for a lot of the stuff that the courts do outside of the, having relations to stuff outside of the judicial branch. With respect to injury in fact, I guess my point with respect to injury in fact, which I take to be consistent with what Jim is saying, is that injury in fact isn't the best label for the kinds of litigable interests that you need to have a case. Maybe it is a decent label for the kinds of litigable interests that you need for certain kinds of cases, like those producing executory judgments, right? Maybe in proceedings aimed to get redress with respect to pre-existing legal relations, I can understand having an injury, framing the requirement, the constitutional requirement, as an injury in fact requirement. But I agree with Jim, that's not the most natural language to use with respect to investigative judgments, like the captors in a prize case. I mean, you could force them into the injury in fact language, but I don't really see much need to. I associate the term injury in fact with Kenneth Culp Davis, not with James Madison. I'm prepared to say it isn't hardwired into Article 3 in all cases, right? That investigative judgments maybe don't need that sort of litigable interest, but they do need another kind of litigable interest. So I'm not sure there's a huge disagreement there, but I'm not sure how much I'm conceding on the injury in fact requirement.
Okay, next there's Steve Sachs, David Moore, and Judd Campbell.
So this question's really for both of you. One thing that came to mind was the example of sort of true in rem cases. It's possible that we could say, as Caleb does, that there's sort of implicitly some owner on the other side, but I'm not really sure that that's true. You know, if I'm sailing on international waters and see a particularly beautiful piece of driftwood come by and I grab it and want to assert my ownership, I could have, you know, Sachs versus particularly beautiful piece of driftwood. And it's not clear to me that there's any real interest on the other side in anything but an extremely attenuated sense. And so I'm just curious sort of how your models handle in rem jurisdiction. The other question that I have is sort of the force of the non-contentious judgments, both in terms of preclusive effect, because I'm not sure that's really the way to put it, because having a non-contentious judgment, it doesn't really preclude anyone, or else they would be able to say, well, where's my day in court? It's more that it sort of has, by doing its work, it has changed the legal relations such that I can no longer argue whether that person is a citizen simply because the court made them one. Not that it sort of determined some outside legal question that I could then seek further review of. But if the real import of a judgment is what it does in the future, then it would seem like a lot of this would come down to sort of how strong was stare decisis back then, and the danger that you see from courts dealing with, advisory opinions or anything else that seems unusual for modern standing law depends on how much force the decision then has. And if it's just, well, fine, between, the two of you can bet on whether X or Y is the law, and we'll get a judgment, and it'll determine whether one of you owes money to the other, but doesn't necessarily bind anybody else, then it's much less clear why that would be the sort of thing we have to kick out of the federal courts. And that's just a pure, abstract normative thought, but I wonder the extent to which the history reflects any sense that it depends on what the judgment's actually doing.
So Caleb alluded to my first question, we referred to hiring law clerks, but I don't know the answer to this, but I wonder the extent to which Congress can assign non-Article 3 functions to courts, things like maybe administering the oath of naturalization, or maybe even some of these pension or naturalization claims where this is just sort of part of the process to obtain a right in the first place. And to the extent Congress can or courts can assume some Article 3 functions, then the fact that a court has done it obviously doesn't reflect on what Article 3 necessarily means, right? I think in these cases, the pension naturalization where the government is arguably the adverse party, I think maybe another way to think about this, and Caleb offered some possibilities, as a sort of prospective default regime where the government just says, right, we're always going to default in these cases. You come in, enter your pleading, and we choose to default across the board. I also wondered, Steve, about the pure in rem cases. I mean, his example suggests that there may be situations where there aren't adverse interests, but I think the pure in rem case also suggests that maybe adverse interest as opposed to absence of adverse parties really is the standard, because you're more likely to have adverse interests, I think, in pure in rem, but not adverse parties showing up, right? So I think, Steve's example, again, undercuts that as the rule across the board, but those examples seem to suggest that an adverse interest, which is more likely to be present in those cases, may be sufficient.
So I think you make a really persuasive case about the oversimplicity of our current account. The question that I have is sort of about the degree to which what the framers were doing was logically derived or thought out, and the extent to which they were just saying, or at least expecting, federal courts are going to act like courts. And what does it mean to act like courts? Well, it was an inherited tradition, and that inherited tradition was a blend of executive and judicial functions. I mean, justices of the peace are in charge of the operations of the sheriff and the constables. So, I mean, the justice of the peace is the administrative officer of the crown, and he is the chief judicial officer of the county. And the framers have some idea of separation of powers that they're starting to work out, but the Constitution is situated in a period of transition, and they really haven't quite worked it out. So I have two kind of historical points. One is that when the framers are when the Congress is trying to enact administrative law, they often use courts because those are the only administrative apparatus in every county in the country. And often they're looking to state courts, of course, to enact collect the alien petitions or whatever it is. The second point that just sort of is an example of what I'm talking about is that there was a widespread practice in the South of grievance petitions, presentments, grievance presentments. So a grand jury, in addition to presenting criminal offenses, would say, the hog catcher is not doing a very good job. We ought to look into that. And that actually carried over into federal practice, which suggests to me that federal courts more or less just kind of acted like and thought they were supposed to act like state courts. And I'm not sure what the normative payoff for that is. I think it depends on what your framework is. You could have a principle of deriving normative principles from all the traditions, or you could have a framework where you try to derive the sort of high-level principles as best you can, but you accept that there are traditional carve-outs. And so legislative prayer comes to mind. Do we allow legislative prayer just because there's a tradition, or do we try to define what the Establishment Clause means based on the accepted practice of legislative prayer? I don't have any views on that, but that's sort of potentially a area of the sort of normative importance of the history that I thought you might speak to.
All right. So let's start with the law clerk versus PACER fee example, which is a good way to get into the question of the distinction between what is judicial and what is administrative or ministerial and would have been understood as such. I completely agree that when a district court judge refuses to hire a law clerk, that decision is not subject to appellate review because we would characterize it as ministerial and not an adjudication. The discussions of non-contentious jurisdiction limited adjudication to the application of law to fact and the exercise of judicial judgment in doing so. It's not a judicial judgment when you decide whether or not to hire or fire a law clerk. That is a different kind of judgment, not one that takes place against the backdrop of the law. But if it does and you violate the law, then you can be subject to suit for discriminating on an inappropriate basis if you refuse to hire a particular candidate for a law clerk position. And that, I think, helps us to understand the difference. If you're acting ministerially in hiring and firing clerks, you are subject to suit as an executive officer when you do so. When you act in a judicial capacity, passing on a PACER fee, you're entitled to absolute immunity when you do so, and no one would sue the judge who denies the PACER fee, or at least no appellate court would permit that lawsuit to go forward. They would characterize the application of judicial judgment to the decision on the PACER fee as an exercise of judicial power that triggers absolute judicial immunity. There's a nice way into the distinction between what is ministerial and what is judicial, and it's very consistent, I think, with the notion that courts perform non-contentious functions in the exercise of their judicial, not their executive power. It is also true, I would hasten to point out, that many people who have experienced the early republic practices have characterized them as chaotic, incoherent, inconsistent. I think of Russell Wheeler's paper, for example, who talks about the extrajudicial activities of the Article III courts in the early years. when Chief Justice Jay goes off to negotiate a treaty and other justices perform other functions that don't seem to be centrally connected to their work on the Article III courts. I would agree that there was some ability on the part of those early justices to accept assignments of work that was not strictly judicial. And that's certainly true in Mistretta and true today, right? Congress can offer judges the opportunity to do other things as long as the judges take care that they discharge their Article III functions and are free to refrain from accepting those assignments if they don't choose to accept them. And that was Jay's situation. He was happy to serve on the board of this and the board of that as long as it didn't get in the way of his judicial function. But once it did, for example, once the court's headquarters moved from New York, where he was hanging out, to Philadelphia, he refused to do it because he didn't want to travel down to Philadelphia to perform the function in question. So he just refused to do it on the ground that it was inconsistent with his judicial function. So I don't see the early period as a period of chaos in quite the way some other scholars have seen it. And so maybe one of the contributions of the paper is to kind of domesticate some practices that were previously seen as incoherent or chaotic. Stephen's questions about true in rem proceedings and the force of non-contentious jurisdiction judgments, I think, are very interesting ones. Because it is true, it is possible to imagine a true in rem proceeding and then wonder what the preclusive effect of that judgment would be. That is, I think, it is quite true, as Caleb notes and as Stephen picks up on. Examples of non-contentious jurisdiction in the in rem context are some of the ones that trouble us the most, and they are the ones that are most likely to present due process problems at the other end. So if you exercise a pure form of in rem jurisdiction in a probate proceeding or a prize proceeding, you are cutting potentially off the rights of interested parties in circumstances that will raise questions about their ability to assert comeback rights at a later date. And that may have due process implications. European countries who have struggled with the use of non-contentious jurisdiction for several centuries now continue to struggle with this due process question. So when German courts confront non-contentious jurisdiction, they recognize that German constructs of due process may require notice, may require a right to seek recusal of the judge, and so forth, so that those due process implications are in some sense implicit in the very idea of non-contentious jurisdiction. And so the preclusive effect of a non-contentious decree will likely vary from situation to situation to situation. I think a fair amount of preclusive effect was given to the naturalization decision, and we cite a number of cases in the longer piece that describe the preclusive effect attached to naturalization decisions. Why? Naturalized citizenship was viewed as essential to the ownership of real property, and your ability to hold good title to real property affected not only your title, but the title of downstream claimants, your children, the people you sold the property to. So if anybody could come back later and contest the quality of your naturalization and unsettle property rights, that would be a most distressing result. And that's why preclusive effect was attached to the non-contentious determination made in the naturalization setting. Less preclusive effect might well attach in other non-contentious settings. I give you probate, where you begin with a common form submission for the admission of the will to probate, which is effective, legally effective, but it doesn't preclude a later claimant from coming in and contesting. And then the court has to switch from a common form of probate to a solemn form proceeding that is a disputed proceeding over the question of whether the will can be really admitted to probate or not. And so in that situation, even a common form determination would not have binding effect that would preclude the right of the claimant who later appeared to contest. So I guess I would just embrace Stephen's suggestion that there are concerns in the true in rem context, and that those concerns may map to some extent onto our understanding of how preclusive the non-contentious judgment ought to be at the end of the day. If we were to fully domesticate the construct of non-contentious jurisdiction, we would have to struggle with that idea a great deal, I think. The question of how binding and what the binding effect is for third parties, given our commitment to due process. Due process killed in rem jurisdiction on the personal jurisdiction side, and it has a lot to say about the exercise of non-contentious jurisdiction as well. David's good question about non-Article III functions and Article III functions is something I tried to address in connection with the discussion of early roles performed by Article III judges, and perhaps I should, for the sake of time, leave it at that. On Judd's question about whether federal courts just act like courts, I think that's quite right. As an instinct into understanding what the courts were doing. And it's certainly true that justices of the peace were exercising non-contentious authority. They were doing things other than settling disputes. Whether they had to sort out, whether they thought of that as a judicial function or a justice of the peace administrative function, it's not clear. There was probably just a justice of the peace manual handy that said this is what you do when you're a justice of the peace, and so they set about the business of doing it. I think you're quite right about the reliance on administrative apparatus, and our approach here would not require Congress to create any non-contentious jurisdiction at all. It would only do so in circumstances where it found that to be a sensible decision, because it wants Article III judges to check the warrant issuance in the FISA situation, for example. But we're not plumping for or supporting the expansion of non-contentious jurisdiction here, simply arguing from the perspective of coherence that it offers a better account of what both the courts actually do and what the Constitution and the terms of Article III suggest. So when I think about normative payoff, I don't think about the normative payoff in terms of empowering the federal judiciary to do more of this stuff. You know, I think the highest and best use of the federal judiciary is probably resolving contentious disputes and not registering claims of right. You know, that tends to be a very fact-bound enterprise, and so, there's no argument here that the normative payoff is to move more in that direction. Social Security Administration disability claims should be handled by the Social Security Administration and not transferred to the Article III judiciary. So, in terms of payoff, it's more in terms of an argument for coherence rather than an argument for expanded reliance on non-contentious jurisdiction. And finally, the presentment question, I think, is quite right. And many people characterize grand jury processes as inquisitorial, fundamentally inquisitorial. And so maybe what you're telling us is that there's an inquisitorial transfer that takes place in the grand jury context that's similar to the kinds of inquisitorial work that showed up on other aspects of the federal docket.
Can I say just one quick thing on the in rem question? So I think I agree with David's take that in Stephen's in rem case involving the driftwood, there are adverse interests, even if you can't identify a particular party who is presently adverse to you, in that when you get title to the driftwood, at least in the old days, you could then exclude everybody else from your driftwood. So everybody else's potential ability to use the driftwood is being precluded by the in rem judgment that gives you clear title as against the whole world. That actually also relates to the probate exception that Jim has talked about. So in Gaines against Fuentes, this extremely interesting case that I had never heard of, and Jim has done us all a service by pointing to, that offers the interesting explanation of the probate exception as saying, well, the key is the probate of a will is an in rem proceeding. I take Justice Field, who wrote that opinion, actually, who 10 years later was saying things about case or controversy that Jim is criticizing. Justice Field writes this probate exception case. I understand him to be focusing not so much on the difference between case and controversy as on the fact that under the existing statutes, the controversies that the federal courts had jurisdiction over were controversies between citizens of different states with a complete diversity requirement. So an in rem proceeding, Justice Field says, in its initiation, all persons are cited to appear, whether of the state where the will is offered or of other states. from its nature and from the want of parties or the fact that all the world are parties. So Field kind of equivocates over whether there aren't parties or everybody's a party. But either way, it's not a controversy between citizens of different states. He says, the proceeding is not within the designation of cases at law or in equity between parties of different states. Now, he's there substituting cases for controversies as if it doesn't really matter. And I think focusing on, is the complete diversity requirement satisfied? Well, not if everybody's a party and not if nobody's a party. So I think there are adverse interests, but I'm not sure that Gaines against Fuentes totally supports the case or controversy line.
If there are adverse interests in the Driftwood case, are there not in the citizen suit under the Clean Air Act from which I can then exclude the agency from issuing the regulation it wants to issue or something?
To me, well, if I take this as a question directed more to my theory of standing than to James.
I think probably, because, although we can probably go a little bit over because we started a bit late, but we still have 6 people left on the queue, so, in fact, more than that. So I encourage people to limit themselves to one question, and the next threesome would be Larry Solom, Sarah Brinton, and Sam Bray.
I had a question for Caleb, but I'll forego it. Thank you, Jim, and really you too, Caleb, for your work. This is deeply illuminating work, and I really appreciate it. So, Jim, on page 61, in the
big honkin' paper or the small honkin' paper?
The small honkin' paper, the absence of originalist support for viewing Article 3 as imposing firm across the board injury in fact and adverse party requirements. Now, here's the part my question is about. Certainly offers no definitive proof against the selective use of such constraints. The federal courts often construct a body of doctrine on the basis of considerations other than those relevant to original meaning. One enters what many call the construction zone, or at least one person does. So I don't understand why you make this assertion. Because, and of course, there's no analysis there. This is just an assertion in the paper. Doesn't your substantive view show that the injury, in fact, and to the extent you're correct, adversity requirements are incorrect as a matter of constitutional interpretation, and therefore that Congress is not bound by these requirements? And if you have a contrary view, where would the authority for the courts to impose such requirements contrary to, right, the Constitution, which seems to say that all these cases are within Congress's power of jurisdiction? So it isn't your conclusion stronger or more have more impact than you present it as having here in these sentences on page 61?
Sarah.
I keep coming to this thought through lots of different doors, so I feel like it's relevant. And it's this, that my understanding is that many at the time of the founding didn't share our strictly tripartite understanding of the powers, right? That actually the judicial power was a subset or some part of the executive power. And people probably know better than I, but I'm recalling, I think that when they were debating the Virginia Constitution of 1776, it wasn't even clear to them, I mean, it was an early state constitution, it wasn't clear to them that they should even have separate courts, and they were talking about the Council of Privy, the Privy Council as an executive part, saying, well, maybe they should just continue to be courts because we've already sort of had the executive doing courty things. And one of the members of the delegates who were there were like, no, it's probably better if judicial stuff is done by only courts. And everyone's like, okay, that sounds good. So they transitioned out of that and ended up having courts as sort of a separate, as distinct from the governor and the Privy Council. And that strikes me, of course, different than the way I conceive of them as sort of being 3 co-equal powers. And there's a lot of maybe political theory from the time that would reinforce that, but at least there was some idea that the mixing that we keep talking about, why were justices of the peace doing these things, why were courts at the time doing these things, is really, they were vestiges of this time when people had a more robust sense that the judicial power was a part of the executive power. So it was mixed it wasn't mixed to them because it was part of one power. I don't know that that's true, and I don't know that it counts for all of the parts of the theory, but I think it gets you a lot of interesting places in terms of, you know, when the government is acting like an administrative branch and when it's actually resolving disputes between, you know, adversarial parties. And I just want to close with a final point that Justice Marshall's formulation that you hold on to actually sounds to me like an executive function. If you just said, when someone asserts a right as prescribed by law, who's going to give them that right? My first thought would be, well, probably some member of the executive branch, right? If somebody had, but maybe that's because I'm a product of my current era where you go through the administrative branch in so many cases first when you're dealing with the government. But anyway, it doesn't strike me that that is inherently judicial in the way he formulated, and maybe that's because they were dealing with the sense that the judiciary was, at least for some part of the time, a subset of the executive power, and then they began trying to parse out what was really judicial and what was really executive and make them separate in a way we have forgotten.
I wanted to throw out two instances of weak or missing adversity. Both are in Borchard's second category of declaratory, to see if Jim or Caleb or both or neither wanted to claim them. So one is interpleader, and the other is declaration that a missing person is dead. The first of those definitely happens, and has happened for a long time in federal court. The second one I know happens in state courts, but I have no idea if it's ever happened in federal court.
Okay, I guess we're going to have
You wanna do
fairly
all the
brief
questions?
answers to the, well,
And we'll do them all at once,
we
or do you want to, how you doing?
we have 4 more people. I don't think that we're going to manage that. But if we could probably answer these questions, and then I'll apologize to my colleagues, Mike, Larry, Myman, and Mila, who get left off. But so go ahead. If you can.
Okay, well, I'll try to be as quick as I can then and give Caleb an opportunity as well. Larry, I think you're onto something there. Sarah.
All right.
Sarah, you're quite right that there was this mixture of judicial and executive power early on. You know, one could argue that this sort of mixing of functions kind of carried right along, and people just didn't think things through very well. But when the judges were talking about what they were doing, they were talking about it in terms of an exercise of judicial power. So when Story, for example, defended the power of the court to review a kind of petition for the remission of a forfeiture of a vessel that was forfeited in the context of a tax collection dispute, he talked about that as if it were an exercise of the judicial power, even though it was demonstrably connected to the executive function of collecting taxes and granting pardons or relief from forfeitures. So they still saw that function, although it looks mixed to our eyes, I guess, as a judicial function. And when the Europeans and others talk about the exercise of non-contentious jurisdiction, they talk about it as if the courts are really performing, in the exercise of judicial power, an administrative function. So the Europeans say, oh yeah, you're registering a claim of right, you're securing a change in legal status, to pick up Caleb's idea. These could be legitimately assigned either to the courts or to administrative apparatus. That's really Congress's decision to make, or the legislative body's decision to make. There's no category that you can impress on the exercise of power. It's really just a question for Congress to decide which institution it wants to assign the role to. So not a platonic essence of administration or adjudication that would distinguish the two behaviors. It's more just a question of Congress having the authority to make the choice, as it has over the years. At least that's the way I would come at it. We have seen declarations of missing persons dead, at least by territorial federal courts, so I guess I would embrace that to some extent. Interpleader feels to me a whole lot like bankruptcy. In the sense that, not entirely, but a whole lot like bankruptcy, in the sense that it triggers an automatic stay in some sense. The whole point of the interpleader is to stop the other litigation and let these parties decide the matter. So I guess I'd be happy to embrace it as well. What do you think, Caleb?
So I think interpleader, to me, there are adverse interests going on in interpleader. The declaration that a missing person is dead, I don't know about. I do, however, know the excellent phrase suggestion of death, which is when a party has died, you make a suggestion of death, which I think is an excellent phrase. With respect to change in legal status and non-contentious jurisdiction, so that's certainly true that there's, in European systems, non-contentious jurisdiction applies to this change in legal status. I do think there's some adversity going on with the changes in legal statuses that the American courts handle. So for instance, even if A and B both want a court to issue a decree transferring property from A to B, I think I would be prepared to say that A and B have adverse litigable interests in the property that's going from A to B. Similarly, when husband and wife seek an uncontested divorce, I'm inclined to think they have adverse interests, at least in the sense that at least ethics rules, as I understand them, typically prevent the lawyer from representing both husband and wife even in an uncontested divorce. I think there's some sort of adversity going on even with the change in legal status stuff. Maybe it's a different sort of adversity than with so-called contentious jurisdiction, but it's not completely non-contentious.
Okay, well, thanks to Jim and Caleb. Apologies to those who didn't get to ask their question. Everyone will sprint down to the reception. We'll get back on schedule.